Hello, everyone. My name is Alexander Nam, and I'm a law clerk here at Lowes Parker. Welcome to today's webinar, hosted by the Home Care Association of Louisiana. Today's webinar is entitled, What's Up with HIPAA? We also have Warren Haybear joining us, and he would like to say a few words.
Thank you, Alexander. I'm Warren Haybear. I am the CEO with the Home Care Association of Louisiana. And just here to thank Lowes Parker for the relationship that we have had with this series of webinars we started last year. We're excited today to have Heidi Kocher and Matt Catoe with us. And the information that you're going to be gathering certainly is going to be refreshing information that's going to give you a good idea of where things are headed with HIPAA and the various challenges that you've got there. Thanks very much, Heidi and Matt, to Lowes Parker also for your good work. And we'll go back over to you, Alexander. Thank you.
Of course. Well, thank you, Warren. So Heidi Kocher is an attorney at Lowes Parker with more than 20 years of experience in healthcare legal and compliance-related issues. Heidi is an expert in all aspects of compliance and privacy programs, including developing and deploying policies, procedures, and training. Her experience includes implementing the various requirements and aspects of a corporate integrity agreement, as well as responding to and defending audits from Medicare, Medicaid, and private insurers, all through the administrative law judge level. Our other speaker, Matthew Catoe, is an associate at Lowes Parker and focuses on healthcare regulatory compliance matters. Matt has experience with auditing claims, anti-kickback statute, Stark law allegations, and assisting clients in regulatory cyber security compliance. He also has assisted providers with medications and compliance documentation when on appeal. As a quick reminder, if you have any questions throughout the presentation, please feel free to type them in the chat box and we will address as many as possible at the end of the presentation. Without further ado, I present your speakers.
Thank you so much, Alexander. Appreciate everybody joining us today. What we're going to do is we're going to do a quick snapshot of sort of what the lay of the land is with HIPAA, and then hopefully give you some suggestions for things that you can do to help you stay in compliance with HIPAA. Next slide, please. We do, of course, need to give you a brief disclaimer. This webinar is general information only. Even though Matt and I are attorneys, we are not your attorneys, and circumstances and legal advice can be changed depending on the specific facts of each case. So if you have specific legal questions, please make sure to check with your attorney. Next slide, please. So this is going to be our agenda. We're going to talk about some recent regulatory changes. We're going to talk about key case law and enforcement actions, some specific challenges for home health agencies that have come up as a result of these enforcement actions. We're also going to look then at some enforcement trends and compliance strategies and conclude with some practical takeaways before taking some questions. Next slide, please. So what we wanted to do is give you sort of a lay of the land, and what we're going to do is actually exclude the Notice of Proposed Rulemaking, the NPRM, that was published on January 6th. This is still in process, and I'll talk about that a little bit more, but I wanted to give you an overview of what some of the other regulatory changes and landscape are out of there. So one of the first things has been the interoperability and information blocking rule. Those were actually published in 2021, and they're really starting to come online now. And what the focus is here is data sharing as well as patient access rights. And interoperability refers to the ability of various health records, EMRs, and so on, to talk to each other and share data. The flip side of that is the information blocking. What they have discovered is that all too frequently, patients cannot access their data, and for various reasons, healthcare organizations drag their feet on giving patients access to their medical records. Another challenge that we have in here is, again, data sharing and interoperability and so on is only as good as your computer connection. And of course, what we see in many states is that we have a lot of issues with broadband availability, particularly in rural areas. And this is something that the federal government was working on prior to the change in administration. We'll see where this goes now. But the problem here is that you have challenges for agencies because you have a lot of decentralized data, how you're going to get that into an EMR and then make it available to other healthcare providers and to patients so that you don't end up being charged with information blocking. Another thing is the telehealth flexibilities. So those enforcement discretion flexibilities for telehealth that were initially implemented during the COVID-19 pandemic, they were set to expire at the end of December with the turn of the new year. But then as part of the continuing resolution for the budget bill, they extended some, not all, some of those until March 31st. Well, we're almost at the end of April, so there's only 2 more months, and we'll wait to see what happens with those flexibilities. And again, here, one of the things that you want to be aware of is the use of telehealth to conduct face-to-face evaluations for your hospice certifications. That's one of the things that was permitted. Another landscape change is the evolving state privacy laws. So this is really focused mostly on HIPAA, which is a federal law. But what we're seeing is state privacy laws are really developing as really well. And they operate with HIPAA, and particularly if you're an agency operating across state lines. So if you're an agency, for example, that might be in the Lake Charles area, and you extend into Beaumont, now you're sort of crossing over into Texas. Likewise, on the other side of the state, on the north side of the state, if you have patients in other areas, you need to be aware of those because you have the state laws. And then again, the states for companies and agencies within the state are also having new developments. And some of the things here are, and I put the California in there because they're actually a bellwether, the CCPA and the CPRA, which really talks about how how consumer data is handled more generally. And the way it is described is it technically exempts HIPAA, but I would consider this a wraparound. You'd be surprised what data is not technically PHI, but actually falls under some of these other classifications that California has implemented. And California's regulatory structure has been looked at and is being copied to some extent across the country. Next slide, please. Another thing that we had was the reproductive healthcare privacy rights. This rule came into an effect last year, and this prohibits the sharing or disclosure of reproductive healthcare information in certain circumstances. People think that this is about abortion, and it is. Yes, it was originally done so, but the definition of reproductive health care is actually far, far, far broader than just abortion. So, for example, if you have a gentleman and he has, let's say, erectile dysfunction and is taking Viagra, that technically is reproductive health care information as well. So, what this rule requires is that if you are requested to provide medical or healthcare data as a covered entity, you must obtain a signed attestation that this request for information isn't used for certain prohibited purposes, which is essentially a law enforcement type purpose. And this actually rule requires all covered entities to modify their notice of privacy practices to support these privacy rights. You should be in the process of modifying your NPP. However, Texas and a couple of other states have filed litigation to block this rule and determine whether or not this rule is enforceable. So this is an ongoing issue and something you should check with your attorney about whether or not you need to modify your notice of privacy practices. And again, this applies to all healthcare providers, not just those that are really in the space of reproductive healthcare. Another thing here is the Federal Trade Commission. In 2024, they expanded their health breach notification rule, and this applies to a broad range of health and wellness apps. And I would consider this like a wrap around HIPAA. So we've got the HIPAA breach notification rule, but then any other health type data beyond what is explicitly covered in HIPAA, and besides the covered entities in HIPAA, are covered under the Federal Trade Commission's rule. So if you have an unauthorized disclosure of covered health information, such as for advertising, this constitutes a breach under the FTC rule. And where this comes in is a lot with the wellness apps. So think, your fitness trackers, and it could also, to some extent, be some things that might not be technically, again, a covered entity, but let's say it is somebody who's providing remote patient monitoring or something along those lines. They would fall under the Federal Trade Commission. Next slide, please. We also had the final rule on the confidentiality of substance use disorder records. Substance use disorder records are regulated under what is called Part 2. And this rule brought HIPAA and Part 2 regs into alignment. And what it is intended to do is increase coordination among the providers who have patients with substance use disorders. And so what it does is it is intended to, again, integrate behavioral health information with other records. And this specifically and explicitly now applies HIPAA breach notification rules and the civil enforcement penalties to improper disclosure of Part 2 substance abuse, use and disorder records. And again, we have state privacy laws. And again, I mentioned California's CCPRA already. Texas also has a Data Privacy and Security Act that became effective July 1st. And again, so these laws are coming on board, and we've got a patchwork developing across the country. Next slide, please. Enforcement in 2024. In 2024, OCR was extremely active. I think they were clearing out sort of the backlog that had accumulated during the pandemic. There were 22 enforcement actions completed, and by that means settlements reached, fines imposed, and so on. This is certainly the second highest in OCR history, and they actually extracted $9.9 million in fines and settlements. It doesn't sound like a lot, but compared to the rest of OCR's history, this is pretty significant. Again, the Federal Trade Commission was pretty active. There were actually 4 settlements with data brokers selling precise location data. You might think, well, what does that have to do with me? But if you have a cell phone, you know that the cell phones can pinpoint your location very, very specifically to within meters of your location. And this precise location data has the risk of disclosing health data. So if you go to the hospital or the doctor's office and the data broker sells your location, then somebody who purchases that location is going to know that you went to such and such doctor, or you went to a psychiatrist or whatever. So that has been a big issue. They also settled 2 cases involving the collection and sale of health information for advertising purposes. And Matt will talk about the Metapixel case in a little bit. But again, FTC is getting involved in this. And then finally, we have state actions as well. Louisiana has a data breach notification law. And in 2024, actually in 2023, St. Landry Parish had schools that had a data breach. And the school board delayed in notifying victims, and they only notified victims more than 5 months after the breach. The Louisiana Attorney General contacted the school board to warn them of their duty to report within 6 days and said, there are fines that are possible. I'm not clear what the outcome is at this point. I couldn't find a complete resolution. It may have just been left at that. But you should be aware that attorney generals, again, are starting to get involved in these kinds of prosecutions. So enforcement on the state level is coming as well. Next slide, please. And Matt, would you like to take it over here?
Certainly. Thank you very much, Heidi. So what I'm about to get into are some of the key big drivers of the recent enforcement actions. These are the headliners. These are the big news articles that have come out, starting with the Primera Blue Cross settlement in 2021. The predicate to this is that there was a phishing email that allowed hackers access to Primera Blue Cross Blue Shield's IT systems for over 9 months. Primera Blue Cross Blue Shield was determined to have failed to conduct an enterprise-wide risk analysis and implement any risk management protocols that would have mitigated the damage. The breach caused 10.4 million records to be exposed to dark web, third-party threat actors, all the way up to just nosy aunts and uncles who aren't supposed to have access to these records. The settlement with OCR cost Primera Blue Cross Blue Shield $6.85 million, and they were additionally tagged with a $74 million settlement in the subsequent class action lawsuit. This is a good point in time to bring up what are known as concurrent proceedings. Just because the OCR tags an organization or entity with a HIPAA-related action does not mean that private citizens, like in the case of the Primera Blue Cross Blue Shield settlement, are prohibited from suing. That means you can face 2 separate legal actions for which the exposure will cause a fine or penalty on the same facts for the same alleged bad actions. As you can see on the screen, the class action is $74 million in one hand, OCR $6.85 million in the other. I leave it to y'all to do the math how much that breach cost Primera Blue Cross Blue Shield. The lesson being, prioritize regular risk assessments and vendor audits. Heidi and I have determined this to be a trust but verify for your security vendors and your IT vendors. We want to believe that everybody is doing what they're supposed to do and keeping on the up and up with all the new rules and changes and regulations that seem to keep coming out and 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 out. But, as is evidenced by the numbers on screen, it's better to trust and verify as opposed to get caught with the $74+ million penalty. A similar example is Athens Orthopedic Clinic. I can't say for certain, but I believe I was working with the insurance carrier who covered these damages at the time that this was going on. The fine is a $1.5 million loss related to failures in safeguarding patient data. The breach actors were able to access private patient health information records, and there was at least some exfiltration, meaning removal from the original Athens Orthopedic systems and onto dark web servers, private databases, or secured solid-state hard drives. So there were certain information that was exfiltrated to third-party access sites that then had to be retracted or worked with to get a hold of in the aftermath. The lesson of this case points out the need for multi-layer security protocols. Most of us would recognize this as two-factor authentication, training, and policies and procedures for what to do in the event of a third-party threat breach. Next slide, please. So, as Heidi mentioned in a previous slide, another one of the big cases is Metapixel's recent health data sharing investigations. Metapixel is a technology that the Meta software family Facebook and all of its own subsidiaries use to track website users' IP addresses and some medical information in order to sell to data brokers that Heidi was pointing out earlier. These tracking technologies are also appearing or were cited to appear in the patient portals. The tool collected private health information and shared with Meta, Facebook, for use in sending targeted advertisements related to information that was gained from otherwise private health information records. Over 80 plus lawsuits have been filed on grounds of breach of privacy, inappropriate disclosure of medical records, violations of HIPAA, and a whole host of other grounds against Meta for the exposure of this PHI. And it also wraps up the original entities who held that data. How dare you allow Facebook to get a hold of my private health information and sell it for profits to whoever the highest bidder was? Approximately 1/3 of the healthcare websites named in these lawsuits are estimated to still be using MetaPixel. The lesson being, make sure there's not trackers in your PHI to make sure that no one's touching it that ought not be in there. Now, the next one is the Anthem settlement of 2020. Prior to the recent Change Healthcare cyber breach, the Anthem settlement of 2020 was the largest data breach in U.S. history. It had just under 80 million exposed records, and it was once again a phishing scam that tricked an Anthem employee into opening an email containing malware. That malware then opened breach points into 50 individual employee accounts, and several hundred million individuals immediately lost the privacy and security of their PHI that was later determined to be ratcheted down to a little under 80 million that actually got their records pulled. Anthem did not discover this breach for over a month. Up until recently, it was a $16 million settlement with OCR and $115 million settlements in consolidated class action lawsuits. The word consolidated should really jump out to the viewers. That means there were multiple class action lawsuits, and absent some skilled lawyering, Anthem could have been taken to task on each of those class action lawsuits if they were not made to consolidate. The lesson to be, secure your remote communication tools, especially for distributed teams. Those of you who are operating across state lines likely need your employees to have access to laptops or cell phones or remote portals that allow them to do their jobs while not actively in the facility. It falls to your facility to make sure that those portals are secure at all times and do not allow external third-party access where it shouldn't be allowed, because your facility and your organization are going to be the first place that OCR looks to balance the checkbook if there is a checkbook to be balanced. Next slide, please. The OCR, as Heidi mentioned earlier, has also started upticks in actions on right of access initiatives. There are currently at least 50 settlements with separate providers for failing to provide patients with timely access to their records. The implications leading, there are also implications for timely compliance in the home health setting. Timely means that in the event that the individual has proven they either A, are the patient in question, this is their records, this is their EMR or their PHI or whichever acronym you want to use, if they have proven that they are who they say they are entitled to their health records as a matter of law, and the facility's failure to get those records to the patient in a timely manner is what OCR is citing in these right of access initiatives. The general timeline is 30 days, give or take a little bit, but we recommend checking with your local state rules and legislatures to make sure that's not changed, as Heidi was pointing out earlier. There's some for reproductive rights, there's some for behavioral health, and whatever fields your practice is operating in, if the patient or requester has proven that they are authorized to access these records, whether it's actually the patient or an authorized medical beneficiary or any number of other relationships that legally they have access to these records, they are entitled to get their full record in a timely and reasonable manner. OCR has also seen an uptick in ransomware investigations. The 8th and 9th settlements were announced in January of this year, specifically Elgon Information Systems, who agreed to an $80,000 penalty and 3 years of monitoring that Elgon will be paying for, and VPN Solutions, who suffered a $90,000 penalty and 1 year of monitoring that, again, they will be paying for. Next slide, please. Finally, we have the Change Healthcare breach of February of 2024. If you are not aware of what happened with Change Healthcare, it was a breach instigated by a sub-worm rotor tool that attached itself to an external email that went into the Change systems and caused a breach due to failure for implementation of multi-factor authentication on a very outdated system. UHC originally paid $22 million to the threat actors, the ransomware people, the mysterious shadow figure on the other side of the computer, but later was re-ransomed based on the amount of data that the hackers realized that they had a hold of and whose systems exactly they had gained access to. Over 190 million patients have recently been determined to be affected across the U.S. That is over half of the United States population's PHI is expected to be implicated within this breach. To date, Change has paid out $2.457 billion with a B dollars to rectify the damages that are associated with this breach. Change has filed the breach report on July 19th of 2024. This is cited to be 5 months after the breach occurred and is a very hot button topic in the OCR discussions. We have reason to believe, though cannot prove, these rumors are unsubstantiated, that Change was aware of the breach long before it was reported to OCR and certainly before any remedial action was taken by federal enforcement agencies. And they are in the hot seat for that, according to the current rumors and the details that we have at this time. None of that is substantiated. However, in November 19th, 2024, Change finally did restore all of their external clearinghouse services. And in December 17th of 2024, the Nebraska Attorney General filed a lawsuit alleging failures to maintain basic measures violated consumer protection laws. Again, returning earlier to what I was mentioning about concurrent procedures. OCR can and will throw the book at Change due to the sheer scale of the breach and the number of patients involved. But this in no way prevents the Nebraska Attorney General from moving forward with this lawsuit. And it's an area of concern we want to point out to the listeners to be aware of how quickly HIPAA breaches can get out of hand and how much you are mitigating if you do the work on the front end. We understand most of our listeners are healthcare providers and want to be involved in the healthcare space and treating patients. We're trying to show you, if you don't do your due diligence on the admin or the cyber side of the house, these examples are how quickly matters can spiral out of hand and what OCR is doing in response to how big these breaches are. There are still over 4 dozen class action lawsuits that have been consolidated and are in settlement discussions, but still over 4 dozen class action lawsuits. And to date, patients in the United States are still being notified once their records have been determined to be affected from a breach that occurred, or at the very least is earmarked, in February of last year. We are nearly a year out from when this was in the news, and patients are still being notified. Next slide, please. So some specific challenges for home health agencies that are raised by these matters. The first is mobile workforces. It falls to the agency to ensure secure data transmission across mobile devices. Make sure your remote portals, whatever form they may take, whether it's a laptop, a cell phone, whatever remote access tools any remote employee is using, is HIPAA secure and compliant, and regularly check in to make sure that nothing's changed. There are challenges in data decentralization, specifically in patient homes, risk of PHI exposure during care, making sure that no one's taking screenshots or Snapchats or whatever the latest social media is of patient health records and distributing them. Even talking to friends among nurses just to say what a patient's record is can be considered a PHI breach. There are obviously concerns with telehealth platforms, especially post-COVID-19 pandemic. We must ensure compliance for HIPAA standards across all virtual care platforms. High turnover rates and vendor management each pose their own individual specific challenges that you can see on the screen. High turnover leading to impacting consistent training and awareness programs, whereas vendor management requires review of all BAAs, third-party billing, and IT and compliance oversight. It can get messy quickly. Next slide, please. What this is all supposed to teach us is that OCR is showing an increased scrutiny towards smaller entities. Home health and hospice agencies often operate with fewer resources than most of these major players that we've been discussing, especially players like Premera, Blue Cross Blue Shield, Anthem, or Change. Most home health and hospice agencies simply aren't as big as they are, but the law is the law, and there is equal accountability demanded of home health and hospice agencies as is demanded of Premera and Anthem and Blue Cross Blue Shield. You don't have to like it, but it is the rules. There is also an increased uptick in data breach enforcement. An example is ransomware incidents targeting smaller agencies specifically because they know that the defenses are weaker because the home health agency does not have the resources to combat external threats on the level that someone like Change does. So the lesson here being, where you can, you should enhance your cyber defenses and at a bare minimum, your breach response protocols. What happens when it all hits the fan? That needs to be wrote and redone regularly within your agency, so at the very least, the entire agency is on the same page when it occurs. Finally, incident response failures. Delays in breach notification, again, are one of the headliners in the current Change healthcare debacle. OCR is very mad that it is implied nearly half a year went by before Change notified OCR or other federal enforcement agencies of the breach at all, let alone the size, scale, and scope of what occurred within their systems. If you are aware of your breach, 9 times out of 10, it's best to lawyer up and have your lawyer write an official response to federal enforcement agencies sooner rather than later, so you don't sit in the same hot seat. Next slide, please. There are also upticks in vendor management and agreements. Primarily, this is focused on failure to secure compliant business associate agreements that lead to fines. We recommend robust agreements and compliance verification for all billing, IT, and external providers. And once again, this falls to trust but verify. It is not and should not be the home health or hospice agency's job to police their IT vendors or their data breach manufacturers. But once again, it is the home health hospice or the home health or hospice agency, excuse me, got tongue twisted. Y'all will be tagged by OCR if it is your records that are breached. Regardless of whether the IT failed or not, OCR is first going to look to the management company who owns the records. Therefore, trust but verify. There are also new rules emerging around data handling and offshoring provisions that agencies should take time to make sure that they are up to date with and are in compliance with, so as to not run afoul of an emerging trend against offshoring provisions and data storage of private EMR or PHI. Technology, as always, is an emerging threat, and especially with new AI posing additional challenges, OCR has determined that most providers are behind the times in terms of security technology implementation. Ransomware attacks will target smaller entities that they know don't have the defenses that bigger fish do. And there are, again, questions about AI and quantum computing as to what this means for the healthcare provider space. It is assumed that most healthcare providers have some HIPAA compliance matters within their IT field and system, but where the fails or where the breaches occur, the lack of up-to-date security technology implementation is a big ticket item in a lot of these new OCR cases that we're seeing. It's not that you didn't have any protection, is that you had protection from, we'll say, the 80s or the 90s or the early 2010s that should have been updated prior to this breach occurring. And the question they're going to ask is, why wasn't it? Do you have a good answer? You should. Next slide, please. Now, obviously, this leads to interoperability demands. Through no fault of anybody using them, Epic doesn't like to talk to other EMR protocols, among other problems. I don't know if you've noticed. Balancing seamless data sharing with privacy protections has posed a challenge within the HIPAA space, and implementing secure interoperability with external healthcare providers has become a challenge for home health and hospice agencies. OCR is looking at it and is aware of some of these defects that are entirely outside of the realm of the home health and hospice world, but they do want to point out that it's still your records, your patient, your records, your responsibility. Resource constraints, staffing issues, and technology budgets have all been mentioned at length at various points in this webinar, but they do pose ongoing challenges, especially for smaller organizations. And agencies must be increasing technology investments, but they cannot rely on break-fix services is the large takeaway that we're seeing from OCR. You cannot wait until the incident occurs, or OCR will be much more hostile in the underlying investigation. The more mitigation any health agency can do on the front end, whether it's comfortable or uncomfortable, if you mitigate, what's the saying? An ounce of cure is worth a pound of pain. I think I misphrased that, but an ounce, it does wonders if and when OCR has to show up, if you have taken diligent steps to secure your cyber environment to the best of your reasonable ability. Next slide, please.
I think the phrase is an ounce of prevention is worth a pound of cure.
Thank you. I knew I missaid it. I knew I said, as soon as I said it, I'm like, no, that's not it, but I'm going to roll with it anyway.
Got it.
Finally, we are seeing some emerging technologies. Again, technology is really at the forefront of a lot of the new HIPAA enforcement models. There's risk of adopting new tools such as mobile health apps without properly vetting them. AI is, as it ever is in the technology sphere, a concern. We don't know if it's going to go up, down, left, right, sideways, and what its role, if any, is in the healthcare space. Remote patient monitoring and wearables, mostly Apple Watches, like Heidi was mentioning earlier, and the integration of that data. Should the Apple Watch be allowed to track your private health information and distribute it with metapixel technology? Yes or no? Did you agree to it? Can you agree to that distribution, willingly or otherwise? And finally, cultural barriers. Integrating a compliance mindset amongst a geographically dispersed field staff and patients who may not grasp the importance of what they're dealing with has always been an issue for even the most diligent of healthcare providers. And the point of these slides is to point out that we are aware of them, and we are aware of the shortcomings and limitations that these challenges may pose, but we also want to point out the risks that come with not addressing them. It's a headache, but unfortunately, it is your agency's headache to deal with. Next slide, please. Bringing it closer to home, Louisiana, unlike all the Fed stuff that we've been talking up to this point, does have their own state version of data breach notification laws. It applies to any entity that holds electronic personal information. Breaches must be reported within 60 days of discovery to the Louisiana Attorney General at the link provided on the page, and absolutely no later than 10 days from that notice should notice be provided to Louisiana citizens that their PHI may be at risk. Affected Louisiana residents must be notified no later than 60 days after the discovery of the breach, and the potential penalties get into $5,000 per violation. I want to stress those last two words of per violation. That could mean a per patient. That could mean a per patient and each individual visit from that patient. The rules change rapidly and dramatically, which means it falls to the agency to have a coordinated breach response ahead of the breach. Make sure that you're not doing this as the breach occurs in real time, and be aware of who you need to notify and when you need to notify them. And once again, it has authorized a private right of action, which means even if the state of Louisiana comes knocking with their state version of the OCR, or the Medicaid Fraud Control Unit, or whomever decides they want to show up and investigate, private rights of action from the patients themselves have been authorized under this data breach law and can lead to similar levels of penalty scaling that we saw in earlier slides. Next slide, please. And now that I've been monologuing about doom and gloom for the past several slides, I'm going to turn it back over to Heidi to what can you do? Here are some strategies for how to mitigate. Heidi?
Thank you, Matt. I don't know that it's doom and gloom. I think it is an objective assessment of what the field looks like. And I think our audience needs to understand that there are some significant risks out there. But if you know the risks, then you can come up with strategies to combat the risks. And the first one here is to conduct regular and comprehensive security risk assessments. One of the things that comes out time and time and time and time and time again in the OCR settlements and investigations is that the entity failed to do a security risk assessment. Security risk assessments have been required since 2003, when the security rule first went into play. And the scope has certainly changed over time, but you need to be doing an SRA, security risk analysis, at least annually or after significant operational changes. And you're wanting to be focusing not just on your office, although that's part of it, but really you want to also focus on remote and mobile access vulnerabilities, including staff devices. Let me just say one thing about the SRA. I view the SRA as something similar to mowing your own lawn or cleaning your own house. Can you do that? Absolutely. Do I want to mow my own lawn in a southern summer? Oh, heck no. So I outsource it, right? And actually, over time, it is cheaper for me to outsource something like that than to do it on my own. So if you can't do an SRA properly yourself, outsource it. We have resources that we can direct you to. But that is one of the key things, because if you don't know what your risks are, then you can't put into place steps to mitigate those risks and address them. So the first thing, the one takeaway if you have from this webinar is you must conduct a security risk assessment. Another thing is to strengthen vendor oversight. One of the things that we're seeing, again, is that breaches are being caused by business associates. So if you have somebody who is doing your billing, if you have an app that works on your scheduling, if you have IT systems providers, you need to have business associate agreements with them. And even if they're not falling within the definition of a business associate under HIPAA, you want to have specific terms for data security in all of your contracts. It's really weird. You're responsible but not responsible, but ultimately the data is yours. And if the business associate fails to maintain it and protect it properly, it is your data and you are at risk as well. So as Matt said, trust but verify. And there are changes coming down the pike where we think OCR is going to be requiring a little bit more on the part of covered entities to verify that their business associates have sufficient technology protections in place. Another thing is that your training programs need to be enhanced. Again, as Matt had mentioned, many of the breaches result from somebody clicking on a link in an email or opening in an attachment. What you really need to do is tailor your training programs, particularly for home health staff that handle PHI in the field as well as in the office. Again, emails are a real source of vulnerability. And even we at the law firm, I got a phishing email just not too long ago, and doggone it, they look awfully real. So you really need to make sure that you tell your personnel to be very suspicious of many kinds of emails. And you want to include scenarios in your training where you have things like inadvertent disclosures, or again, the phishing emails. Another thing that is coming up is people are failing to do proactive monitoring. Virtually all EHR systems now have detailed access and modification logs. You should know where those logs are. You should be pulling them and looking at them routinely. Sometimes that is the first indication that a breach has occurred. If you don't know how to do that, contact your EHR vendor and ask them how to, and again, make sure that you do that. And you can also ask your IT vendor for advanced tools to detect unauthorized access. The days of just assuming that unless you absolutely know of a breach, there is no breach, are long gone. The hackers nowadays often lie in your systems. I was at a presentation by a cybersecurity FBI special agent, and he said that the typical hacker stays in your system for almost a year, checking out where your files are, what trees you are, what kind of data you have, before they do something like exfiltrating or triggering the ransomware that locks up your system. So make sure you have those tools in place and ask your vendor about them. Again, as Matt said, an ounce of prevention is worth a pound of cure. Next slide, please. So again, you want to adopt secure technology solutions. You want to use HIPAA compliant telehealth and EHR platforms. Most of the EHR platforms that are sold in the US actually do meet the federal standards for a certified EHR, but you want to make sure you have that and verify that as well, particularly if you're using something homegrown. We're not seeing that as much anymore because, again, I apologize for the dog. Pepper, quiet. Because what we're seeing is people are no longer using their own EHR platforms. They're using the commercially available platforms. Hang on, let me get the dog real quick. She's seeing a delivery person here. So you want to make sure you are using a commercially viable program that has a lot of those protections built in on them. And again, you want to make sure you're encrypting your mobile devices to prevent unauthorized access. That includes phones, laptops, tablets, anything like that. You want to develop incident response plans. You need to have a clear understanding of how the breach notification and remediation works. When a breach happens, the clock starts ticking, and you do not have a lot of time to figure out the process and the policy at this point. Make sure you know what this is ahead of time. You want to have workflows worked out. And again, you want to involve an attorney. As Matt noted, the fines and penalties very quickly start piling up. I am working with a client on a breach right now, and boy, they had a class action lawsuit filled as soon as we filed, as soon as we issued some of the notification letters. So you actually really do need legal help pretty quickly. And then finally, make sure you have the right kind of cyber insurance. You want to ensure that your coverage aligns with the specific risks of your operations. Make sure you understand what triggers coverage and what any exclusions are. Every single cyber insurance policy that I've seen looks different. There is very little commonality among them, so make sure you understand what your cyber insurance is. I've also heard of a recent trend that because of the impact of cyber breaches, that what cyber insurance companies are doing now is if you do a security risk analysis and you get a receipt from the company doing the security risk analysis, or you can document what the cost was, they will take that as a deduction and reduce your premium by the amount of the cost of the SRA. So that's also something to look into. Next slide, please. You want to make sure you're regularly reviewing and updating your privacy policies. When there is a breach or an investigation, OCR does ask for your policies, and they want to make sure that you have looked at them. In theory, you should be updating these or at least reviewing them on an annual basis. If you don't have a policy and procedure for HIPAA matters, you need to get either doing those in-house or work with attorneys or a vendor to come up with that. Again, you want to develop relationships with IT vendors. As Matt said, the break-fix services or managing IT on your own is no longer going to be sufficient. The technology is just moving too fast, and you will not be able to implement some of the things that you will need to be doing, like vulnerability scans or penetration testing. That's really something you want an IT vendor. You're just going to have to put this into the budget. Technology vetting, you want to make sure that your technology tools meet HIPAA standards. If you are implementing any specific new tools, you want to talk to the vendor about what they're doing to meet HIPAA. And by the way, there is no such thing as HIPAA certification. So if somebody says to you, oh, I'm HIPAA certified, that should set up your antenna, because there is no such thing. You want to know exactly what it is they're doing to meet HIPAA standards. Beware of data offshoring. Again, states are beginning to prohibit data offshoring, especially in the Medicaid contract. Texas, for example, is one that explicitly prohibits data offshoring. CMS requires Medicare Advantage plans to have attestations about the protections for offshored data and the use of offshore vendors. So they are, of course, then going to turn around and ask those vendors and their participants for their providers for those protections as well. And again, private insurers are also including offshoring prohibitions in their contracts. So you need to be aware of where your data is. Is it geographically located in the US? Not just your data, but if you're using a cloud-based system, where is the cloud storing it? Remember, the cloud just means really somebody else's computer. So beware of that as well. Next slide, please. So emerging technologies and risks. AI is really, really changing the nature of the risks out here. AI runs basically on computer programs. It's an algorithm. You want to make sure that those algorithms comply with privacy regulations. You want to make sure that your team is not putting data into ChatGPT or any of those other AI tools. We also have, again, the risks of data mismanagement in these automated tools, scheduling, patient monitoring, completion of records. You need to understand what is happening with the data and what those vendors are doing in terms of risk and management of the risk. Wearable devices. Again, how do we handle patient-generated data from connected devices? Does that go into your EMR? How does it flow through? How does the patient connect? What are the protections in place from these wearable devices? Internet of Things. We also have compliance challenges with connected medical devices. So if you have, for example, remote blood pressure monitoring, and I'm not talking Apple Watch, this is actually a medical device that connects to the internet in the patient's home and then transmits data to the EMR. What are you doing with that? You need to, again, understand what the risks are and what the protections are. Third-party services are a huge emerging risk area, including the cloud storage solution. Change Healthcare was a clearinghouse, so that's a third-party service for many providers. That should scare the living daylights out of anybody. We have a lot of risks with third-party data handling and storage, and again, beware of data offshoring. I think that's going to be the next big thing. Next slide, please. So we've got some emerging best practices, data minimization. This is the minimum necessary standard. Everybody talks about minimum necessary, but they never really think about what that means. I think we all need to be a lot more conscientious about limiting PHI exposure to what is necessary for care delivery. In your EMR, people have different levels of access based on their roles and jobs. That is something that should be definitely tailored to what an individual's job responsibilities are. Not everybody needs to have access to all of the EMR. And again, what else is out there? Not everybody needs 100% access. Encryption everywhere all the time. So in the original security rule, encryption was a best practice, but the technologies had not evolved to the point, and many people were still on paper-based records, so that encryption was really just more of a good practice and a suggestion. Again, times have changed. You really need to be encrypting all your devices and communication channels. You know, set up a VPN to help with that. You cannot anymore have non-encrypted devices and communications. You want to think about privacy by design. You want to include privacy safeguards in your workflows and technology use. You want to think about how do you implement privacy from the get-go rather than doing sort of an aftermarket bolt-on and add-on. Privacy has to be part of your approach to everything. And then finally, you want to audit your data privacy and security practices. Again, it starts with a security risk assessment, but there are more and other things. Auditing is going to become more and more important because if you don't audit, you won't know if there's something going on until you have a breach, and then it's too late. Next slide, please. So looking ahead, we've got trends. Again, we've got increased enforcement with the focus on mobile healthcare providers, including folks like hospice and home health. You are all out in the field. OCR is very concerned that there are significant risks out there that are not being managed. We've also got technological innovation, and that is by definition going to drive some new compliance strategies. You've got to have continuous staff education and adaptation of best practices, and you want to have a lot of collaboration between your compliance, IT, and field operations. Again, this is partially will be revealed when you do a security risk analysis, but just again, it's sort of an ongoing thing. A couple of other things. OCR published a notice of proposed rulemaking to make actually some fairly significant revisions to the HIPAA security rules. This was issued on January 6th. I'm not going to go into this in a whole lot of detail. I'm doing separate talks on this. But basically, there is a significant increase in technical requirements. I have never seen language like OCR used in this rule about, oh my God, people, you are not listening to us. You need to do. And then there's a whole bunch of technical requirements. Again, encryption, multi-factor authentication, penetration testing, and vulnerability scans. All of this clearly points to a need for increased investment in your technical aspects. You, again, cannot do this on your own anymore. I strongly recommend that people work with an IT vendor who understands HIPAA. Not everybody understands HIPAA, but to be able to enable some of these things. An ounce of prevention is worth a pound of cure. And then finally, OCR is restarting their HIPAA audit program. So they had done they had done audits of covered entities a couple of years ago. They took the results of that in part to inform the notice of proposed rulemaking. But what they're going to do is they're going to pick a number of entities, and they're going to, again, audit them to see for their HIPAA, their compliance with the HIPAA privacy and security rules, Again, one of the things that they have explicitly said is that they are going to be looking at the security risk analyses. So go get your SRA done, please. Next slide, please. And that is our presentation. We are open for questions. Alexander, do we have any questions from the audience?
No, I don't see any questions. Well, thank you so much to all of our presenters, and thank you to our attendees for joining us today. I will be sending over a copy of the PowerPoint slides tomorrow, and if you have any further questions, please feel free to reach out to them. I hope you all have a great Tuesday.
Thank you all.
Thank you, Heidi and Matt and Alexander. Have a good day.
Thank you, everyone.
Bye-bye.